Now, things get deeply personal. Edwinia Johnson isn't just fighting criminal charges, she's fighting for her family. Between forgery counts, probation conditions, and CPS supervision, this case walks the razor's edge between justice and compassion. Every decision here decides not just her future, but her children's.
Good morning. Are you Maria Garza?
Yes.
And Ms. Garza, this is your initial appearance in cause number 25 DCCR 1008. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 15th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I was told that they had gave me attorney Courtroom.
Right, and so while you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, I'm going to expect you to try to hire your own lawyer.
Okay.
So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk right here. She'll give you a reset. Just sign this first, and then you can grab it on your way out.
This next case pulls no punches, a $60,000 theft, a plea deal, and a probation gamble. Sydney Lewis stands before the court hoping to dodge a felony record, but 10 years of probation and massive restitution. That's not freedom, it's a ticking time bomb dressed as a second chance.
The only thing that I would add, Judge, is that we now have an agreed restitution figure
That's
for the court.
my question.
Yes,
What is it?
$60,000.
Okay. All right, ma'am, you are Sydney Lewis. And Ms. Lewis was previously here in cause number 24 DCCR 1905, entered a plea of guilty to the third-degree felony offense of theft of property. I've received the pre-sentence report. Have you both had an opportunity to review that report?
The defense has, Your Honor, we have no objections. Yes, Judge.
And Mr. Smith, any objections or corrections?
No objection.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You are ordered to follow all of the rules and conditions of probation, and that includes paying back the restitution of $60,000. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, you'll never have a felony conviction. The case will be dismissed at the end. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, you could be found guilty of the offense, and you could go to prison for anywhere between 2 years and up to 10 years. Do you understand? Also, $60,000 is a lot of money to pay back. And sometimes what people will do is they think, I'm going to wait and I'll pay a little bit next year when I get my tax return, and maybe I'll sell this in a year or two, and I've got 10 years, so I've got plenty of time. You will be surprised how quickly that time will pass. And at the end of the probation, you could have done every other thing correctly. And if you don't pay that restitution, and I make a finding that you could have, you can still go to prison for up to 10 years at the end and your probation be revoked. So I want you to pay something on the restitution every single month, because even if it's not a huge amount, it will add up over that time frame. Does that make sense? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. When probation's ready to go over your paperwork, she'll call you up to her desk, all right? Good luck to you, ma'am. Thank you.
Thank you.
Now, things get deeply personal. Edwinia Johnson isn't just fighting criminal charges, she's fighting for her family. Between forgery counts, probation conditions, and CPS supervision, this case walks the razor's edge between justice and compassion. Every decision here decides not just her future, but her children's.
Good morning, you're Edwinia Johnson. And Ms. Johnson was previously in court, entered pleas of guilty in all 3 of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery. I think and I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct? And
Answer yes or no, please.
Yes, sir.
And your client at the time had asked you to dispose of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was gonna cash them, so I'm just as guilty as him.
Of the four.
So, and she said in here that she's the one who took them.
Yeah.
So I'm
Mr.
okay with
Smith has
that.
brought it up, and
Okay.
I want
I had an
to
issue
clear up
with her
culpability.
responsibility.
I appreciate that. Yeah, I
And,
agree.
they've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't been around.
Okay.
Thanks.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss them, but I didn't have paperwork on probation.
Okay.
Um,
What,
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the, won't abandon and get some of the CPS rules. I didn't see that.
well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
The plan is
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and they,
We can go talk to Judge Shelton maybe, or no, is this is fine?
no, I mean, that's as long as but she's gonna have to give her probation officer documentation
Yeah, I have
from
all of it.
CPS, so you can work that out with your probation officer. So mine's gonna be no unsupervised unless, and then if
yes,
probation
okay.
gets that information and she's doing her safety plan and everything, then we're gonna be okay with that here also. But they're gonna kind of be the ones that dictate that process, not
It was
me.
just kind of nebulous. A couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay, all right, so
Get
Ms.
this
Johnson.
done is what he told me, so.
Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm gonna start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right? Good luck to you, ma'am.
Across these 3 cases, the courtroom showcased the full spectrum of accountability, from the search for redemption to the consequences of delay, denial, and debt. Maria Garza's appearance was a quiet storm. A second-degree felony charge for aggravated assault is no small matter. The judge's tone revealed both firmness and fatigue. She's seen too many defendants stall, hoping leniency will outlast responsibility. Garza's struggle to secure a lawyer isn't just procedural, it's existential. The system gives her time, but not sympathy. That's the harsh arithmetic of justice. Every reset carries a cost. Sidney Lewis's case was a masterclass in conditional mercy. 10 years of deferred adjudication sounds merciful, until you realize it's 10 years of surveillance. $60,000 in restitution looms like a shadow. The judge didn't just hand down probation, she handed down a lesson in financial accountability. Sidney's future hinges not on remorse but on monthly payments. The warning was crystal clear: treat probation as grace, not freedom, or lose it all at the finish line. Then came Edwinia Johnson, a story that cuts deeper than any charge sheet. Her crimes are tangled with poverty, caretaking, and family collapse. The judge's ruling blended legal precision with human empathy, probation instead of prison, but under CPS oversight. Here, justice wore 2 faces: the enforcer and the reformer. The message was loud. The law might punish the act, but it still roots for redemption. What ties these stories together is the silent war between second chances and personal responsibility. Each defendant got an opportunity to rebuild, but the margin for error is razor thin. The real drama isn't in the verdicts, it's in the next 10 years of choices they'll make. So as you watch these cases unfold, ask yourself, would you rise to the chance or fall under the pressure? Is mercy a gift, or another test you can fail? Because in this courtroom, second chances aren't handed out, they're earned. If you found these cases as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.